Hello and welcome to our SME series on managing people, where we should be looking at how to write disciplinary allegations. This episode is just one of many which forms part of our wider series looking at the employee life cycle within an SME business. And our first important piece of advice is that an allegation must be clearly articulated. But what does this mean? Well, it means an allegation must be specific and succinct, clearly identify which rule has been broken, and detail the specifics about the situation, so the when and the how. And a really important point is that special focus must be made to those allegations that are of a gross misconduct nature. Gross misconduct allegations, if founded, can lead to summary dismissal for first offence. And so for gross misconduct allegations, they must be written in a way that tells the employee that the incident is gross, by which we mean it's at the most severe end of the spectrum of unacceptable behaviours. It could even be criminal. Gross misconduct allegations are also matters which can be deliberate, willful or negligent, and so including this terminology is really important too. And finally, due to the seriousness of a gross misconduct allegation, and because there's a real threat that it can destroy the employment contract, that should be included. So why do we need to be so careful about how we write an allegation? Well, it's because of the need for procedural fairness. One of the tests at tribunal is whether procedural fairness has been adopted by the employer, as is required under the Employment Rights Act. In addition, we must also be mindful of previous case rulings, since the test of procedural fairness has also been developed by case law over time. And finally, a tribunal will expect an employer to follow the practical guidance set out in the ACAS Code of Practice on disciplinary and grievance. But what does ensuring procedural fairness mean to an employer? Well, having that clearly articulated allegation, it means the employee can effectively prepare for their disciplinary hearing, which is really, really important for fairness. And it also means the employee can effectively participate and have the right to reply. So with that in mind, we have a top tip for you on how to construct an allegation. And with an allegation in this example, you will say that it's an alleged breach of, or it's a failure to follow, and then you would look to add the specifics, so the date, you allegedly, and then set out the brief details. And so, for example, it could read something like this: that an alleged breach of the company's absence management policy, specifically between the 1st and 4th of April, you allegedly failed to follow the company's absence reporting procedure when absent from work. So don't forget when writing an allegation, it's important that you're specific and succinct in doing so. Be clear on which rule has allegedly been broken, detail the when and how, and in the case of gross misconduct, state that, use phrasing such as willful, deliberate, gross negligence, and warn the alleged act as a potential breach of trust and confidence, if founded. And that brings us to the end of the video on how to write disciplinary allegations. Thank you for watching. Be sure to check out our other short videos in the series. And if you'd like help and support on managing disciplinary in your business or would like to discuss your HR requirements, please do get in touch with us via the information showing. Thank you.